Okay, welcome back everybody to the Vocational Science of Freedom online law class. And this will be the fourth segment where we'll be covering the special master appointment and how to use the Vocational Science of Freedom Status Docs in court and the process of how to put people under binding arbitration, those who have administered your estate and have entered into contract with you. So the special master's appointment was a document that stemmed from the teachings of Bill Thornton at 1215.org. And he talks about, if you go through and listen to all of his lectures, which I highly suggest everyone do, because it's a very good primer into courts of record and the difference between courts of record and what is not a court of record and how they operate. And he, not to give any spoiler alerts, but he tells a story in one of his lectures about that he was appointed as a special master in the Superior Court of Record. Now, in California, it says in the California Constitution that all courts in California are courts of record. But if it does not operate as a court of record, then is it technically a court of record? And the answer is no. So what had happened is that someone's estate body had been potted, thrown into a jail for whatever reason, and they had filed a habeas corpus. And they appointed Bill as a special master of the Superior Court. And so when he went to court, he made sure that he finagled a little meeting with the judge in chambers prior to the hearing, because he wanted to, not kind of just barge into court and be like, take over everything, but to explain to the judge why he was there and what he was doing. And he said that when he was in the judge's chambers, an attorney came in, looked him over, saw, nice three-piece suit, tie, whatnot, and figured him for another attorney and just started talking. And lo and behold, what the attorney started talking about was the very case that Bill was there as appointed as a special master, which he explained to the judge. He said, I've been appointed as a special master in the Superior Court. I'm just coming here to observe today the proceedings, and I just want to let you know that, there's been a habeas corpus filed, and I'll be overseeing that habeas corpus and so on and so forth. And this was all before the attorney walked in. So the attorney walks in there, and lo and behold, he starts talking about the same case that he's talking about. And so the judge stopped that immediately. He said, because he knew that if he didn't, that the attorney would be in deep shit, because you cannot do that. You cannot talk to the judge without the other side being present. Now, of course, we all know that they do that, but it was funny because Bill said if he would have wanted to press the issue right then and there, he could have. But he didn't. But the judge cut it off anyway, and he said, this is getting too complicated. Let's go on the record. So and so the hearing started, and the district attorney did his thing. And then Bill said, and I'm so-and-so, and I'm just here to oversee the aspects of this court and observe the proceedings, I believe is what he said. And so they started to do their thing back and forth, and I'm sure Bill said something, and something got either interjected or he said something about, well, there's been such and such filed and yada yada. And the district attorney got up and said, Your Honor, who is this man? I don't know who he is. I don't know what he's doing here. And Bill said that the judge just stared him down. Just stared down the district attorney and then just went right back to Bill as if that attorney wasn't even in the room. He said it was the most blatant disregard for a prospective attorney he'd ever seen before in his life. And that went to tell him that, he was on the right track. Like before, he said he was kind of worried about what they were doing and, with this work and so on and so forth. But he said after that, he said he knew he was good and what they were doing was correct. So from that standpoint, I took that. I learned everything there was to know about special masters and what they are. And as Bill describes in the recordings, it's pretty much a judge without the pay. And as I said before, in the Federal Rules of Civil Procedure, you can find the rules for appointing a special master, even in federal court. And I knew from the basis that, just based on pure raw reason, that if we're sovereign, we have the capacity to appoint whoever the hell we want to staff our own courts. So a special master should be no different. And of course it isn't, as Bill's proved and lived out, and I've proved and done things as well with the special master appointment. So this is a special master appointment for filing into a court of record. Now, you do not file this document just into the inferior court, meaning you do not file this document into a traffic case or something and have it expect to do anything. What you have to first do is you have to file a counterclaim or something that goes over the top of their inferior court case. Now, that can be a habeas corpus if you want it to be, because a habeas corpus is basically a family fight between jurisdictions, between courts. It's not, a habeas corpus is not considered to be an actual lawsuit. It's something that gets filed to say, hey, wait a second, we're in the wrong jurisdiction here. We need to be over here. So, and that's how you should file it. You should file your habeas corpus in a court of record, not in the inferior court as a statutory habeas corpus, because 99.9% of the time they'll just dismiss them because they don't care. But if you file a constitutionally based habeas corpus in a court of record and you do it correctly, then you can appoint a special master to walk in there and take care of business for you, which is exactly what this gentleman did with Bill. That's how the document's laid out. So you'd have your name, whoever was there, and whoever the case so-and-so. So this is the executor or the executrix, which you could put executor here, EXOR, dot, and care of, and then where the address to send the paperwork is, so on and so forth, right? That's your little boilerplate stuff, and then the clerk of the court can put their file stamp up here, right? And say, in the court of record of Winnebago County, Iowa, or whatever the county and the state is. And you want to put it, and I know this seems odd, but you do want to put the heading in Old English, because there is a clear distinction. At least I learned this in California, because there was another gentleman named Richard McDonald who has a lecture up, a fairly old lecture. I don't know if the man's still living or not, but he has a lecture up about the difference between a state citizen and a citizen of the United States. And he talks about that he noticed that there is a difference in the superior courts. They're actually being run as superior courts in California, and they have their headings in Old English. So I took that for face value, and I said, okay, fine. Well, if that's how I do it there, that's fine. Do it here too. So I make sure that the heading is in Old English, so that they know you're coming in, absolute common law aspect of it. So you do the heading, what it is, where you're doing it, and then plaintiff versus defendant, case number, whatever it is. And this case number, if you're filing a habeas corpus, this case number should correspond with the habeas corpus filing, not with the inferior court. So again, make sure that you're filing everything in your superior courts of record. So what is it? It's appointment of special master to the court. It's verified, attested, and it's sealed. And so what are we doing here? Appointment of special masters to this court of record. Comes now, John Henry, House of Doe, one of the people of wherever. Plaintiff in this court of record, sovereign of this court, hereinafter plaintiff. And in this court of record now appoints the following people as special masters in and for the above entitled court, and declares and lists their duties to wit. And then you name whoever you want. Those who you appoint as a special master, you want to make sure that they either have experience in court or they are well versed in whatever they're doing there for that day, meaning if it's habeas corpus, so be it, or whatever else, and that they're competent to know what they're doing. Because the last thing you want to do is appoint a special master, have them walk in there, and then be an idiot, because that's not going to go over well with anybody, and it's just going to make things worse. But if you walk in there and take control of everything, like Bill did, you can get somewhere. You can force it. You can force a constitutional habeas down their throat, because there's hardly ever a damaged party, right? Where's the damage, harm, loss, or injury? It doesn't exist. And so what you do by a habeas corpus is you're demanding that the inferior court produce the damaged party. You're not demanding that they produce the plaintiff, or that they produce the plaintiff in the habeas, meaning, because habeas corpus means produce the body. So most people think, oh, it means produce the guy that's in jail to go over whatever the case is about, why he should or shouldn't be in jail. No, that's not how you should do it. What you should do with a constitutional habeas is you should demand that they produce the damaged party. Produce the body of the damaged party. Who did I harm? They can't do it. They got to let you go. That's how you do a proper habeas corpus in a court of record, constitutionally, and the argument that you want to make in it. You do not want to bring the body of the accused before the court. You say no, bring the damaged party. And when they can't do it, then you do a default, lay it out, and finish it. And we have full habeas corpus templates as well, which anybody who bought the entire Vocational Science of Freedom hard drive has. They have all of the habeas corpus templates in there. So anyway, to continue here, so you state who you want your special masters to be, so on and so forth. Are one of the people of Iowa are hereby appointed by plaintiff as a special master of this court of record for life or until the appointees formally relinquish their appointment or plaintiff removes them from this office by notice and written, signed, and sealed letters. The above listed special masters may perform, should the need ever arise, in and for the above entitled court the following. Anything that the sovereign plaintiff of the above entitled court can perform. So that's how I lay it out. So that if they have you basically vest them with all your power, and you can alter that however you need to see fit. Like if you see special master appointments, federal court, a lot of the times it's for filing or doing subpoenas or depositions or accounting of some sort or such and such which or whatever. The duties will be labeled in there usually as to what you want them to do. So I just vest them with all my power, because if someone's going to come and take you and put you in a cage somewhere, you'd better have vested someone with all the same powers that you have in your own court, because then they can file documents, they can sign things for you, all that. So yeah. So subject to the limits that the sovereign plaintiff of this court wishes to impose by rule, law, verbal decree, or written decree upon the special masters. The only restrictions or limits to the above listed special master's powers at this time are: at no time may any special master change the law of the case nor add to it. Special masters may not appoint any other special master without the express written, signed, and sealed consent of the sovereign of the court. Any other powers and limits of power regarding special masters may be listed in the law of the case. If a difference of opinion arises between any special masters, the sovereign plaintiff will be contacted as soon as possible to resolve the differences or dispute. All special masters shall keep a record of all their actions and dealings with the above entitled court and file that report with plaintiff after each activity they participate in. That's just making sure that you're all keeping good records, that you're not if you have more than one special master, that they're not stepping on each other's toes, meaning that they both didn't file a habeas corpus at the same time they're not talking to each other, something along those lines. You just make sure that that's all, that everybody knows what everybody else is doing. And then your verification and this is how the verification of the vast majority of court records, the court documents, right? So you have verification. Plaintiff declares under penalty of perjury above the laws of the United States of America and under natural and common law that the foregoing is true and correct, and that the appointment of special masters herein listed to plaintiff's court of record is approved and verified by plaintiff in and for this above titled court. So on and so forth, blah, 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 executed. And you put your signature here, and you're a state dignitary, plaintiff, one of the people of whatever, paterfamilias of the house of wherever. And then teste ipso, this is basically this is your own, by your own hand, you're testifying to your own, what you're doing here. So John Henry House of Doe, sovereign of the court, holder of the seal of this court, with said seal thereof hereunto affixed, attested by his own hand, who stands upon the land as one of the people of Iowa, this whatever day of whatever year, whatever. And then this is where your house seal would go, right here. And then I, one of the people of wherever, accept the appointment of special masters, the above entitled court of record, from the plaintiff and sovereign of same, and on my oath will perform my duties as a special master of said court to the best of my abilities, and affix my signature and seal to this appointment in honor of my own free will, act, and deed. And this is where your special master would sign and put his seal or her seal. And then that's it. That's all of it. And then you just file this into the superior court case number. And again, not the inferior court case number, but the superior court case number after you get one with it, habeas. Or if you filed a counterclaim, that's fine too. You can put it in there too, because then you would have a superior court case number that would differ from the inferior court case number. And a lot of the times, and not always, so this isn't a hard and fast rule, but a lot of the times you'll have the abbreviation AL, which means at law, or sometimes it'll just be L and then the case number, meaning law. And then usually the inferior courts will have EQ for equity, or CV for civil is usually how you can tell the differences between the two different kinds of courts. And trust me, these two different kinds of courts exist. They exist in every single state. You have to realize what they're doing, and you have to understand how to do it properly. And so this is what you would file to get your special master appointment in. And then your special master can show up, and your special master has to be given any other documents that would be sent to you, basically. So they have to, if the other side puts in something, a motion, whatever, then it also has to be sent to the special master, right? So that's the special master appointment. So let's move on to the next doc, which is the handbill for the marshal appointment. And the marshal appointment is very much like, it looks very much like the special master appointment. It's almost the same, for the exception that the marshals are different. Your special master can do basically whatever you can do in court. You appoint marshals. The marshals of your court are to enforce what your court does. So if you literally wanted to appoint your entire local militia as marshals of your court of record, you can do that. And then they can go out and enforce whatever it is the decrees of your court state as far as findings of fact and conclusions at law. Okay? So the marshal appointment is a document that is to be filled out only if you have an open court case. Now, that's not exactly true. You could technically fill them out beforehand, but you would just leave the case number blank, basically. So you could fill them out beforehand to have for emergency purposes, basically. So, but you'd only file it, right, when you have an open court case. The fact that one can staff his or her own court with whomever they see fit to staff it with is a right that every sovereign has always had. This is shown still to the day in the Federal Civil Procedure, as I stated. The plaintiff can appoint a special master to his own court, and unless the defendant objects to the appointment stands. That's even in the Federal Civil Procedure. So you could just make the rules apply to the same standards by simply putting it into the law of the case. The appointment of your own marshals works the same way. Now, you will not be able to point to some rule of court or to some statute or code to show any public trustee that you can do this. What you can do is use your logic and reason to know that if you can appoint one kind of officer to your court, you have the same right to appoint any other officer to your court, which includes but is not limited to law enforcement officers of your court, which is exactly what a marshal is. The who, what, when, where, why of this document is as follows. The marshal appointment is only filed when you open a court of record, common law court, as a plaintiff, and decree the law and rules of the said court. It cannot be filed as a defendant in an inferior court. And if you want to learn more about that, again, like I said, go listen to Bill at 1215.org and he'll tell you all about it. Number two, the why of the marshal appointment is this. We cannot trust the ignorant law enforcement that has been employed by filthy corporations acting as de facto government any longer. We just can't do it. That time is gone. We must have our own lawful enforcement of our own rulings and findings of proper grand juries and petite juries, or else we shall never take back what has been stolen from us in our own constitutional republic by the bar associations. Sovereignty is about self-government, and there is nothing more sacred to a free man than to hold his own court and bring justice from it upon those that have caused damage, harm, loss, and injury to him or his property. This is what kings and queens do. Who can fill out the marshal appointment? Anyone who has come of full age, who has filed a common law action in a court of record. What is the marshal appointment? It is a decree and appointment from your own court that states who is to staff your own court as the law enforcement officers of your court. They can include the local sheriff, if you trust him, the United States Marshal Service, if you trust them, and anyone else that you trust to know and understand civil process and civil criminal process at law. You must serve the marshal appointment on to the other party who you're going up against. So make sure after you file your marshal appointment and your special master appointment that you get a file stamped certified copy from the clerk of the court, and make sure that you serve it on the other party so that they know what's up, right? So they can't ever say, oh, I didn't know what you're talking about. This guy showed up at my house and I shot him. Well, no, he was an officer of the court and you knew that. So anyway, where do you file the marshal appointment? You file it in your action at law when you open up your case at the clerk of the court's window. How to fill out the marshal appointment? It's basically the same way as I just showed you in the special master appointment. So this is all same boilerplate stuff as what's in all the rest of the handbills. This is how to fill it out. Okay. So that's your That's your marshal appointment. And let's go on to the next document. And this is an email that I sent out to people a long time ago regarding, because people were having questions about land and allodial title. And so I made a simple little email here. And this corresponds with, I think, what we covered in probably, I think it was section 2 or part 2 of this class today, was where we were talking about how the land has been altered into doing zoning and the aspect of use in Roman civil law of use of being that we're the use of fructuary and they see us as trustees and not owners of the land. Okay. So this gets back into the Declaration of Allodial Lands and how to fix that. How the Declaration of Allodial Lands that you can fill out, or you can have us fill out for you, from the Vocational Science of Freedom ends these presumptions. Okay. So as for the Declaration of Allodial Lands, the people who have fully paid off their house are the best candidates for the filing of that document. And that's not to say that you can't claim the land right out from underneath the house of which you owe money on, because you can do it, because this is all about the land, not the property. And by the way, don't confuse those two terms. Land and property are two different things. Because you owe nothing on the house and have no mortgage hanging over you. What we have created for the Declaration of Allodial Lands is a lawful reboot of the land record. It states that you claim the forever clause of the original land patent and that you are transferring the land from your estate to you, the living man or woman. Now, because many of the status docs that you have done came much later than the Declaration of Allodial Lands, that specific aspect of the doc is necessarily as important as it once was, because we pretty much take care of everything in it now. Those aspects of what I just spoke about are pretty much all taken care of in all of the rest of the doc set. The Declaration of Allodial Lands was something that almost predated, well, it did kind of predate all the rest of the doc set. And then when we realized what was going on, we're like, oh, okay, this is about what our status is to be able to do these things. So that part of the problem is not so much an issue. Yeah. However, other parts of the Declaration of Allodial Lands are still very important. In the Declaration, we the people are declaring the lands to be allodial and not to be bound by any feudal tenure as per the Wisconsin Constitution. Now, you can use other states' constitutions in any other state. The answer is yes, if it is the exercise of a right that one of the people in another state have. Meaning that if you have the right to own land and allodial title in one state, you have the right to that same right in all of the states. And that's, of course, under the federal constitution, equal footing. So when we declare the lands to be allodial, we then go after the county and demand that they produce a higher claim to that land or remove the land from the public property tax rolls, right? The idea of zoning, which we were talking about before, is it residential, commercial, agricultural, right? And so that's where you're getting rid of these labels that you're using the land at all. You say, no, I own the land. I have title. I have highest title to it. Now, I'm going to pause here for a minute and tell you another story about, there's another gentleman, Hawk, who's on here, who's a vocational science member, vocational science freedom lifetime member, that he went down to his county assessor's office, I believe is what it was. And he went down to the county assessors and he said, okay, I bought my land and this house with cash. He paid $250,000 cash for it. And he said, where's my title? And he kept bugging him about it. And they said, well, we keep the titles in a secure location so in case your house burns down. And he said, excuse me? So they admitted straight to his face that they are holding the titles. So we know they have them. And all of this land shitcanery happened around late 60s, early 70s, where they altered and changed all this. And to use my logic and reason, I would say that it probably had to do with the fact when Nixon dropped the gold standard. That altered the aspect of what they were doing with the titles in some way, shape, or form. But I've never tracked down exactly their excuse or their reasoning for doing it. I just know what they're doing, and I know how things used to have been done. But the exact things of what they changed, I'm not 100% sure about. But I don't worry about it so much because I know how to undo it anyway. So, and the other thing that we do, you'd file preliminary to this, is that you file a 3-set notice to the county recorder, and basically to the county itself, to the county assessor, stating to them unequivocally that you do not want any benefit nor any services or privileges from the county at all. So you immediately sever any presumption of contract that you have with them and say, nope, I don't want any of your stuff. I don't want your backwards government schools. I don't want your fire department. I certainly don't want your police. And so get away from me. And so once you cut off the contracts, then you can stand on it and say, oh, no, yep, I don't have any contracts with you. So screw you and stay off my land and take it off the public tax rolls, right? Or you're going to find yourself in a court of record with me suing out the title in an action of ejectment, where you, in an action of ejectment, that's a common law action. Well, it's kind of considered a mixed action, sort of. So it's like this weird hybrid. Anyway, in an action of ejectment, what you're doing is you're saying, I'm holding title and I'm ejecting you, whoever you is, in this case being the county, out of the lands forever. And you have to produce, or the county has to produce, some sort of evidence that shows that they have any interest in your land. So you do that notice pretense to, I mean, you have the declaration of lordly lands ready to go and filed, but you file those 3 notices before you file your declaration of lordly lands. Then you put the declaration of lordly lands down, and this gets recorded onto the this does get recorded onto the land record now. So you are looking for the county land recorder if that differs from the county clerk, but sometimes it is the same place. So just be aware of that before you go filing. Just check to make sure where you got to file the land records for this. So now the other thing that I have to go down with it. Okay, so it's a declaration. So it's a kind of a 1-2 punch. So it's 1, 2, 3 sets of the notices you serve on the county after you file the declaration stating that you do not want any services from them and that you demand that they produce the contract to show you ever agreed to tax this forever. And when they can't produce it, you serve them with the status doc set and tell them to put up the bond amount stating therein or stop administering that part of your estate. If they still do not back off, you can take them to binding arbitration and take that $300 million out of their hide under international contract law and binding arbitration. Now, like I said, someone has done this and now has a lien on several judges' houses in Colorado, all of which are recognized by the Secretary of State of Colorado. So if you want to go with them, you're welcome to follow in his lead. And then there's Hawk, which is the other fellow I talk about in here, where Hawk actually took the declaration of lordly lands. He literally barged into a meeting of like 10 state representatives that was having a meeting in Northern Illinois or something, and he actually like went into the building and it just said, where's so-and-so? And he said, oh, he's down the hall having a meeting in room whatever. He's like, great. So he goes down there, he busts in on these guys, and there's like 10 state reps sitting there like having a meeting, and they're like, can we help you? And he's like, yeah, you can help me. So he drops the declaration of lordly lands on him. He said, this is what I've recorded onto the county record. And he said, the county land records, and they're all giving me hell about that I still have to pay property tax. And the 10 reps, they literally took, all of them being attorneys, of course, took a look at the declaration of lordly lands, and they said, we don't see any problem with this document at all. So, and now the declaration of lordly lands is the top document when you go and look up his land records. So there can be no more color of title if the true title is claimed and declared to be a lodio. So that was an interesting side quest, if you will, of how Hawk deals with things. He just goes straight at them. So if you want to do the declaration of lodio lands, the first thing you need to get is a certified copy of the original land patent from BLM, the Bureau of Land Management. It's not difficult to do. Blue Star's done it. A few other people have done it on here. You just call them up and ask for one and send them the money they want for it, and then you'll get the legal description of the land, which is sometimes called the meets and bounds. It should also be in your closing papers for your mortgage or your house sale, usually. So you can also go to the county and ask for a certified copy of that because they have to give it to you. So once you get all that, you can do the declaration of lordly lands and put it all together in a sandwich and then file it on the land records under a land patent or acknowledgement of patent. Because if you file it as an acknowledgement, you're acknowledging the original land patent. So only you can do an acknowledgement. So you acknowledge that this thing, that you've brought forward this thing, and you're acknowledging it. So that means that you're bringing forward the original land patent all the way from back whenever. You're bringing it forward, meaning you're bringing it forward into the record, and you're acknowledging it on the record along with your declaration of lodio lands. So you acknowledge the patent and the declaration of lodio lands. Okay? And I said, if your state is goofy with the categories, just ask them for a printout of what the options are and then email them to me and I'll tell you which one to pick. So then when you file it, then do the notices and then hit the county up with a certified copy of the KW. Properly process them with everything. And then you give them one last time to get the hell off and move it off the Roman civil law tax rolls. And if they don't, you hit them with binding arbitration. Or you can file in a court of record as ejectment, because as I said, the KW has both options there for you. You can do either one. So you can do binding arbitration or you can do court of record. It's up to you. So that's a little aside as on the Declaration of Allodial Lands. And the next document will be, okay, this will be getting into how you do your BC audit. So this will be a request for your CUSIP number for the fidelity bond that's connected to your BC. And this company's been fine. Plenty of people have used this company already. And it's Real Net Marketing. So it's the CUSIP research. This is literally from them. This is the form. This is the request form to get your CUSIP number for your fidelity bond that's connected to your BC. So you send them in this request form by U.S. mail, and cost is $250 per search. And if a number is given, it can't be found, there's no cost. And if you do a research on commerce and derivatives market, you'll see the chances of not finding a CUSIP number associated with the given number are less than 5%, or sorry, less than 0.5%. There are that many numbers in the system, and that's it's that huge. Every single thing out there has a CUSIP number on it, basically, is what they're getting at here. So anyway, these are the different ways you can pay them. And this is the information that you'll get, and then the turnaround time and the additional information, and this is the request form. Okay, so that's all given to you, but then what I want to also add here is that show you guys the letter. This is the open letter that Blue Star wrote to go along specifically to the Real Net Marketing people, the ones that I just gave the doc for, and as to what exactly you want. So it is my understanding Real Net Marketing assists people with Bloomberg searches, audits on mortgages, loans, birth certificates, court cases, CUSIPs, and social security numbers. My wife and I would be most interested in having the search audit done for a birth certificate and mortgage for the amount asked in the request for CUSIP search form, which is what I just showed you. Please also assist us in finding the minor specific number associated with our relative portions. Now that's important because there's a minor CUSIP and a major CUSIP. And if you just ask them for the CUSIP, they'll probably just give you the major one, which will show you the total tranche of everything that's in the entire fidelity bond. And that's not what you want. You want the minor number associated with your portion. So because the point of this is that to do the BC audit on the fidelity bond is that after you get your whole status docs done, you get this done, you can turn around and you can serve fidelity with status docs. Now, and we were going to write a letter to fidelity as to the reason why they're being served and demand from them the bond. But nobody's done this yet. So if anybody wants to hurry up and do this, be the first ones to the door, feel free. You don't necessarily even have to wait for the letter. Now, there are people that are waiting for the letter, and I'll get it done. And because someone else was supposed to be working on it and they didn't get it done, so it's gonna drop back onto me to finish it up. But it'll be short and sweet, and then we'll send it all out to fidelity, and we'll see what they have to say. I can't really see what they could much say other than here's your check, because you'll have them dead to rights. The audit that has all this information in it, what they also do will send you. You can also tell them in the amount in the audit form that you want a screenshot. So make sure that you tell them that to provide a screenshot of the findings out of the Bloomberg terminal. And by the way, anybody that doesn't know, a Bloomberg terminal is like this little, it's kind of like they look like little laptops. And they're directly connected into both the NASDAQ and the New York Stock Exchange and the bond markets. And in order to even have one of these things, you have to have a medallion stamp, which is a broker medallion, which is something, basically a seal. You have to have a broker seal. And then you have to pay for the renting, because you can't own one, but you can pay for the renting of a Bloomberg terminal. It's like $15,000 a year. Actually, I think it's probably gone up now. It's probably something more like around 25 or I don't know, some ridiculous amount that you have to pay to rent these things. And so this is what you're having this company do for you, is to be able to get in and access with this Bloomberg terminal the information on your BC and the CUSIP number that goes with it to the bond that's attached to it. So this is the basic aspect of it. You put your house seal down here, both you'd sign, so on and so forth, if you're doing, two of you, and then they'll send you back the information. And I'm not going to give out anybody's specific information here because obviously it contains private information. So that's your Bloomberg terminal audit for the CUSIP numbers from them. This is the cover letter you would send with the request. And let's go back to the outline here. Okay, now we'll get into the next section. So why we all need to get our status docs done before we can form de-jure grand juries in our counties and control our realms with ultimate and complete power. Because the aspects of everything that I've been teaching as far as the status docs are concerned, and the reasons why you have to do them, is to overcome the presumptions that they would ever bring forward to say, oh, you can't form a grand jury. You're a bunch of infants. Well, no, we're the people. We're the sovereignty over you, in case you forgot. Therein lies the very problem, is that they've not just forgot it, but they've tried to bury it. The fact that our status as one of the people, so lawful heir and executor, executrix of our own estate, lawfully domiciled on land, held in allodial title by us, and the establishment of our own houses must be declared on the public record to rebut the presumption that we are only merchants who are residents on property, and that we only have the use of, and therefore can be taxed with property taxes for that use, which is everything that we covered today. In the last vocational science of freedom civics class called Rebuttable Presumptions, How Tyrants and Black-Robed Priests Enslave the World, we covered the presumptions that they use against us in great detail, so I will not take the time in this class to go over them again. And you can also follow the mega. You can click on the mega link in the description for this episode and download the documents for that class. And just to pull it up here quickly, I will show you the outline for the last class. I'm not obviously going to try to go through the two classes at once, but I'm just going to cover this stuff. So what we talked about in the April class. So what's your status? We covered the Sester Vi Act, the aspect of what the individual master file is, that the presumption of death is actually labeled into the IRS master file, that you've not come of full age, so how to correct that, and where it says that in the Magna Carta. The definition versus executive versus administrator, which I actually did give to everyone in this class. The Form 56, the IRS, the state EIN. I gave the redacted boom letter, and gave Drew's bonding information about when we did the FOIA on his bond. The heir versus beneficiary doc, their Jerome Daly case, which is about what are Federal Reserve notes. Some definitions here, and so the explanation of what happened to our states, what happened to the 14th Amendment, the aspect of contracts, what the different kinds of contracts are, so on and so forth. A history of the grand jury is to understand that this is our out. When we all get together and we start to form grand juries, that's over. We have total power then. But we got to get there first, and we have to know what we're doing when we do get there. The 3 requirements of any case, facts, evidence, and the law. So I covered that more in detail as to what to do in cases, how to file and prosecute an action at law. So I covered much more in detail how to do that. Brief discussion of the 13th Amendment, and then gave some archives as to where to find the rest of the good reading, which one should look for as far as foundational documents and so on. So that was the outline of the April law class. And I just wanted to show that quickly for anybody that hasn't watched that class yet, the importance of everything that's in it and how I go into much more detail, and that I've just skimmed over some of those things today, but in that class I cover them completely. So yeah, and it rebuts all the aspects of the Roman civil law, which I stated. Because here's the aspect of it. Once you accuse yourself of being something or having a particular status, then that decreed status stands until they rebut it. So if you say you're one of the people, that's a claim. And then they have to rebut that you're not one of the people. Because your status is whatever you say it is. Right? So now let's get into up the document. Cops have no duty to protect you. This is just basically why I want to show the importance of the status doc from a standpoint that there's no obligation for them to do anything for you. You have always been your own protector. Okay, but this is directly from the Attorney General of Texas. So opinion regarding when a peace officer has a duty to intervene to prevent another peace officer from violating the rights of a citizen. Dear Representative White, you ask about the duties of Texas peace officers. You describe the policy approach. Public policy is not public law. Public policy is what you do to administer the infant's estates. Public law applies to everyone, and that's a damage, harm, loss, or injury. Right? So just to make sure we knew that. So Okay, so the policy approach of some police officers departments requiring law enforcement officers to intervene to stop colleagues from using unreasonable force, i.e. violating a citizen's constitutional and civil rights. Notice how they separate them. Constitutional and civil rights? That's because these two things are completely different. Anyway, so this is what the thing's about. I'm not going to read it. I'm just going to go down to the end. Thus, we cannot conclude that there is an absolute duty for an officer to intervene under the circumstances you describe. Got it? It's not there. They don't have it now. They've never had it. They have no duty to protect you whatsoever. Period. You have to protect yourself. So let's get into the next section, the entire binding arbitration process of the status docs. So how you serve the status docs, public trustees, and why they are bound to obey your executive orders when you take them into binding arbitration and when they are in default. So after you've created and filed all the status docs, you will want to start process serving them onto all the trustees. I have a master service list of trustees to process serve. We don't have to go over it. You can just take a look at it, when you get to that point. It's just basically a list of everyone that you could possibly think of to serve under township, city, county, state, federal, military, corporate, credit reporting agencies, and international. Right? Now, do you have to do all this? No. Like I said, the main ones you want to hit are your Secretary of State of State and Fed, and your county sheriff. Would probably be the third one that I would pick. And then you could serve the probate court of your original birth county. Would be number 4 if I were to do it in a specific order. So the proper way to use all the status docs to have them served onto as many trustees as you can before anyone or any corporation or government comes after you, your estate, or any trust derived therefrom. When did Noah build the ark? Before the flood. Every trustee will not have all the status docs served on them. There are certain docs that will be used and served on some others that you will only serve under certain circumstances. So traffic tickets. So judge of the inferior court, chief judge of the county, district attorney, court administrator, bonding company that holds your case bond, and do the FOIA request for the bonding information. Foreclosure cases would be the original bank, any law firm that is representing anyone who is trying to foreclose on the mortgage already sold, and the judge of the inferior court. Debt issues, this would be the registered agent of the corporation that originally opened the account with your credit, any collection agencies that are idiots that come after these idiots, 3 credit reporting agencies, bam, bam, bam. Criminal charges against your estate, that'd be same as traffic ticket. Replies to notices from corporations and municipalities to the agent that sent you the notice from them, or the registered agent of the corporation that sent you the notice. So every corporation has a registered agent, which is the agent that is designated to take service for that corporation. So they're totally used to taking service. You get the registered agent address and you're within distance of being able to get there. Take your friend, go ahead and drop it off. Trust me, it'll be a walk in the park. It'll probably be the easiest service you ever do because that's all they're there for. They're just there to take service. That's all they do all day. So anyway, so that's the registered agent. Property tax issues, that'd be the county board, tax assessor, county treasurer, corporate counsel of the county, and maybe your local state representative. That's kind of an option if you want. Fidelity, obviously the registered agent of Fidelity. So once the status docs and the KW get served on the appointed trustees, only then does the clock start on them to perform as per the contract. You cannot retroactively serve a doc and then say, oh, and you owe me $300 million because you didn't do it. No, you got to give them the time because you have to stay in honor too, right? So remember that the only way to enter into the contract is if they administer part of the estate. So if you can't prove that they've administered the estate, you can't put them into binding arbitration. Remember, anyone who can read a contract knows that they do not want to enter into this one. Period. If you can read, and you can read this contract, they want nothing to do with it, trust me. And we do not want them to. We don't want them to have to. However, if they are administering any part of the estate, and you can prove it, as an account or in an account in the estate or trust name, a bond in the estate or trust name, or suits that may be in the estate name, then they bind themselves to the contract by failure to give you a full accounting and livery of all that they are administering to the lawful executor and executrix, and closing out and ending the charges administration of anything that they're doing. And then 3 things that we prove are right in how we have created this contract, the KW, the story of Lowe's, and everything I talked about tonight already. What happened to Phil, Jinx case getting dismissed, and the boom letter as far as the child support getting zeroed out. Okay, so the clock. Here's the clock from a standpoint of what they have to do once they get served with this, the amount of time and what they have to faithfully execute between a certain amount of time. Okay, So any appointed trustee who has bound themselves by performing any binding action stated herein to any degree stated herein shall be, quote, bound trustee or bound trustees. Bound trustees agree to faithfully carry out and execute all causes of claim as stated herein within the term stated herein, after being served with the claim or having notice of claim, notwithstanding any request from a bound trustee for more time to perform said as stated herein. I give them a grace period if they ask for one. All appointed trustees who perform binding action 1 shall be hereinafter trustee in honor or trustees in honor. A trustee in honor are vested by claimant for 120 days with all the needed powers to fulfill all executive orders herein and other executive orders given to them by claimant in addition to what is stated in claim. So you're only vesting them with the power to do what you've given them in the order to do in here. That's it. Nothing else. That's all they get. A trustee in honor shall remain so until discharged by claimant or until the 90 days of non-performance of the clauses they bind themselves to herein. Furthermore, all bound trustees until they are discharged by claimant, as stated in section 6.0 below, agree to be bound and be under absolute perfect obligation to perform and obey all the controlling clauses listed in section 6 below, agree to stipulate to all the facts listed in section 7 below, agree to be and shall be fully bound to all law stated in section 8 below, agree to understand and stipulate to all definitions listed in section 9 below, and agree to all the terms and binding clauses listed in section 11 and elsewhere below unless otherwise stated herein. That's where you wrap them up and just everything that's stated in all those sections, but all those sections are fairly lengthy because, like I said, it's a 33-page document. They're all bound to. You just flatten them with everything all at once. Failure to respond within 90 days of being served with claim. All appointed trustees have 90 days from being process served with or having notice of claim to respond to claimant at the address above with any corrections, questions, or challenges to claim, in writing, point by point, via registered mail, and provide proof of trustee's claim to the contrary, under oath or attestation, and behind the appointed trustees full commercial liability and under penalty of perjury. A lack of response or non-specific response that does not contain proof of claimant's possible mistaken understanding regarding all that is stated herein shall be seen and agreed to by all bound trustees as a full and complete agreement of claimant's understanding of all that is contained in claim. So if they try to give you some stupid boilerplate, mail you back, we don't understand what you're talking about, great, they just bound themselves to the rest of the contract anyway. Failure to dispute all claims made herein will result in an automatic default judgment and permanent and irrevocable estoppel by acquiescence and tacit procuration on the part of all appointed trustees named herein and all third parties. If any appointed trustee performs binding action 1, the then trustee in honor will then agree to waive this section 6J forever and be bound to all that is stated in claim regardless if they have sent the stated response or not. So what I'm doing is I'm making sure that there's no way out of this. All facts declared herein must be rebutted by bound trustees within 90 days of being served with claim. Claimant's obligation to discharge trustees in honor, is trustees in honor agree that they shall remain trustees until they fulfill all the executive orders below, and instructions from claimant stated herein, as well as all other past and future orders from claimant regarding everything stated in list within 90 days of service of claim. Now, the list that I'm talking about here, that's why it's a capital L list, because later on in the document, I define what that capital L list is. It's basically a ridiculous library of information and data definitions as to what you're claiming in your state. And I'm not even going to begin to go down it because it's several pages of a list. So, if any bound trustee requires anything from claimant in order, other than what is decreed stated in order herein to accomplish and faithfully execute any order or clause stated herein, it is the wish of claimant that bound trustees send a written list of what they need or require from claimant to accomplish all that is decreed stated in order herein. And it is the wish of claimant that the trustees do so within 30 days from having knowledge of or being served with or having been given notice of claim. If any counter offer from any appointed trustee or any third party is included with said written list from the appointed trustee, it will be seen and understood as an attempted fraud upon claim, meaning this whole status being the KW, and be seen as an attempted administration upon the estate. If said condition is met by any bound trustees, they agree to be bound to binding clause 3, trustee in default. Furthermore, if bound trustees fail to send this request to claimant within 90 days of being served with claim or having notice of claim, said trustees agree that no other instructions or orders are needed from claimant to perform, fulfill, and accomplish their obligations under claim. So, trustees in honor, after a full accounting and livery of all stated in list for the estate and trust has been completed, as stated herein, shall collapse all trusts and send to claimant at the address above proof that said trusts have been collapsed and are no more within 90 days of being claimed. Okay, so trustees in honor, after a full accounting and livery of season of all stated in list for the estate and trust have been completed as stated herein, shall collapse all trusts and send to claimant at the address above proof that said trusts have been collapsed and are no more within 90 days of being served with claim. If trustees in honor fail to accomplish this obligation in executive order within 90 days of being served with claim, trustees in honor agree to be trustees in dishonor and agree to all clauses under binding clause 2 herein, which is everything that they have to be bound to as a trustee in dishonor when they do not fulfill their contract. Okay. Trustees in honor may be granted more time to perform the stated executive orders if they send a written, signed, and sealed request to claimant for more time to perform said, with an explanation as to why they need more time, that is to the satisfaction of claimant, before the said term of 90 days expire. Trustees shall consolidate, merge, settle, liquidate, sell, and convert everything of a financial nature stated in the list into lawful dollars as defined herein or gold bullion. Shall contact claimant for an appointment to deliver the same by bonded courier to the address claimant provides, and shall bring forth, deliver, and satisfy a livery of season all other physical, corporal, and incorporeal objects, things, titles, lands, issues, bodies, rights, immunities, souls, effects, papers, children, and the like, not of a financial nature listed or stated in list, to claimant within 120 days of being served with claim or having notice of claim. If the appointed trustees fail to perform said within the stated 120 days, trustees agree to be trustees in dishonor and be bound to all the terms and conditions of Section 12 of claim. So, those are the clauses that are literally taken directly out of the KW. Okay. Now, to simplify all this, so this is the clock simplified out of that contract language. So the first one, what? After service, if they administer anything of the estate, they become bound trustees. 2, before this point, if they don't administer anything, they're only appointed trustees with no obligations to perform, right? So everybody is an appointed trustee, but they only become bound trustees when they start administering something of your estate, which you told them not to or whatever. 3, a bound trustee has 30 days to ask any questions about the contract or what their obligations are under it. If a bound trustee fails to perform all that is stated in the contract within 90 days, they become trustees in dishonor and have to put up the bond, and you get to take power of attorney over them, which is not mentioned in the clauses that I just read, but that's also part of the KW. So they've got 90 days to do what they're supposed to do. Once they don't do that, you can take power of attorney over them, and you can force them to put down their bond. If after 120 days of non-performance, they become a trustee, then they become a trustee in default, and then you can take them to binding arbitration or sue them in a court of record for the bond amount. After they are found guilty to be in a court of record or an arbitrator rules against them for the violation of the contract, they then become trustees in default of judgment arbitration award and agree to be indicted and tried as a common law thief under the penalty of which is death by a grand jury. Okay? Any questions? Because I'm done fucking around here. These people are going to obey us or they are going to be hung. End of story. The very fact that we're getting murdered out here from people, whistleblowers, telling the truth about what's happened during this election fraud is pretty much, I mean, not like there wasn't enough before that, but as I said before, you were at war. All the status docs do is draw that line in the sand absolutely lawfully so that there's no question of who you are, what you are, and your relationship to them. None. Zero. And you have them now under contract. They want to keep enforcing ridiculous contracts against us. Great. Nullify all of them and put a contract over them, which is what this does. And so this is all that they agree to. Right, so they agree that they will be indicted and tried as common law thieves, the penalty for which is death under the common law, if they are found guilty and or in a court of record, or if they get the arbitration award against them for violating this. That's a common law thief, without question. That's the definition of a thief. You took it from me. You stole it. Bam. That's it. Common law thief. End of story. That's why they hate the common law, too, as a side note. That's why all the bankers and attorneys hate common law, because they know under the common law, first time penalty for thievery is death. You hang a thief. So, so after they enter into default with an arbitration company for a hearing regarding the breach of the contract, so then you file the request and all evidence that proves that they administered the estate and the process service affidavits that prove that they were served with the KW, as I previously stated. You give all the names and addresses of all the locations of all the trustees you want to take into binding arbitration. So some companies restrict you to only so many respondents per fee per case, meaning arbitration companies. Sorry, I should have made that clear. But to be sure to just ask them about the policy before you go and set up and hold an arbitration hearing. So just know what they need and know how many people you can put on their bus per hearing, if you will. Most of the time, 90% of the respondents will never show up even after they have been served with the notice to do so in the binding arbitration proceeding, which leads to you getting a default award as per the contract. They just don't think it counts. They just don't think it matters. Or they were just too stupid to understand and read the contract. Either way, I don't care. Many arbitration companies will hold hearings over the phone or over video conference, and I guess that is during the time of Corona scare. They would almost always do this now anyway. So after you have an arbitration award, there are many ways that you can use it. You can put it in the public land record of someone who owes you, and it will count as an automatic lien on their house and lands, which they'll never be able to sell their house, and they'll never be able to take out a equity line of credit or anything along those lines. And so anyway, check your local rules on liens in your state regarding the process. We know that this is how it works in Colorado because I already stated that. You can get the arbitration award confirmed in a court so that you can use the sheriff, state, or federal marshal, federal court to go and collect and seize the property of the trustees in default. Now, federal court, what they balked with was that because Drew was in Colorado and he went against state judges, they said, you don't have a diversity of citizenship issue here, so we don't have any jurisdiction in the federal courts to confirm. Even though Title IX under USC says it's a summary process, which automatically is granted jurisdiction. So they're trying to desperately get out of the idea that Title IX doesn't grant jurisdiction to the federal courts to confirm. But as I said, there's 1,000 ways to skin a cat. And then the third thing you can do is you can begin another action on the award itself. So you can do an action of account at law for court of record. You can do a writ of assistance. You can do a writ of garnishment. Or, as I said, you could probably even take out on the commercial side, or thinking of commercial solutions, you could probably take out an equity line of credit directly against the judge's house. You could sell the award. You could foreclose on the award. So there's a whole bunch of other things you can do with it. So what do you need to do if your estate is named as a defendant? So in any court case, what you need to do is have it dismissed as a defendant. So we'll cover how to file a suit in common law, but I cover this more in detail in the rebuttable presumptions class. So even though I'll just go over it kind of your general thing of what you want to do here, and then you can cover the rest of it there. So civil or criminal, and the rules of court, and so on and so forth to lock down the judge. Now notice to everyone, this is not the way I would go about winning. That would be to file as a plaintiff in a superior common law court of record. So what I'm showing you here is just what you would do to get out of the inferior court. Okay, so just the notes that I made here, right, to remind people of that. So have your sovereign status immediately at first instance so you claim it. You say, look, I'm one of the people of Colorado. I am the sole lawful executor of the res defendant that you're attempting to administer here. Who brings claim? Can you begin that with the cop right on the side of the road? Now, we talked about, and maybe CLF3 would be nice enough to share his doc, but Blue Star is right, because anyway, he's got a document that you can literally give to the cop on the side of the road that says, I can't talk to you for all these reasons. I'll have to see if I can't find it at the end of class and post it. First instance is first instance. And I've had a lot of discussion with this with old fellas that, men that came before me that have studied this stuff for a long time. And a lot of them, or some of them, at least not a lot of them, but some of them being ex-cops. And they said flat out to me, first instance is when we pull you over on the side of the road. That's where they consider first instance starting. So the jurisdiction starts the second you open your mouth to the cop. So the first thing out of your mouth, it better be a direct question like that, or they will consider you to be under their jurisdiction. Now, the presumption of the license plate and the registration of the quote-unquote motor vehicle will be a presumption enough for them to basically go after you. But that can also be squashed right at the side of the road too. And you say, I'm not engaged in commerce at the moment, and I have no lawful contracts with the corporate state. What do you want? Right? Or something to that extent. You can say it a lot of different ways, or you can just literally hand them CLF3's document if you want to, which is funny. Which says that you can't talk to them for all kinds of other reasons, aside from the ones I just stated. But anyway, so to continue. Number 2, then it must be stated and filed onto the record. Yeah, that's one of them. Thank you, Blue Star. That it must be stated and filed onto the record of the inferior court before any arraignment happens in any court. So arraignment is where they get you to agree to the jurisdiction of an inferior court and to bypass your rights that you would have, your constitutionally protected rights that you would have if everything were being done in a court of record, right? Where this is just this thing of due process that most people don't realize. There's a couple of really important court cases. One is Heath versus Boyd, which I think is a Florida case, and then Texas versus White, which I think is actually another Florida case, even though it says Texas. Or wait, that might be a Texas case. Was that? Yeah. Anyway, I think these two cases are the two most important cases, and they're in my law of the case, by the way. That's on the law library, the VSOF law library. And what these two cases are showing is that the second that a cop pulls you over, if they arrest you, they have to take you directly to the nearest and most accessible magistrate. Now, that does not mean that they get to take you to jail, book you, and then throw you in jail for the weekend. And on Monday, when they get around to it, when a chancellor shows up to get around to it to do his business, that's following that law. No, no, no. The common law says, upon arrest, you must take them before the nearest and most accessible magistrate, whether on a warrant or not, which is even more interesting. So even if, say, they had a warrant for your estate, and they actually produced it and actually had a wedding signature, they would have to take you directly before the judge or magistrate that signed that warrant. And I don't give a goddamn if it's 4 o'clock in the morning. That's what the law says. That's why major cities like New York have night court. Okay? So that they can somewhat adhere to that rule. And if they don't take you directly before the nearest and most accessible magistrate, literally the cop on the side of the road has committed armed kidnapping. The second that they turn their wheel towards the closest jail and not towards the closest and most accessible magistrate, that's kidnapping. That's armed kidnapping. And Heath Boyd was an interesting case because technically he did take him to what he thought was the closest magistrate, which was like, I think it was like the county administration building or whatever, wherever this county sheriff had his office at, right? Took him there and said, okay, you can have your phone call and blah, 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 blah. But the problem is that there was a magistrate only 10 miles away, closer. And because of that difference in the distance, they ruled that no, the officer should have known where the closest and most successful magistrate is. That's his frickin' job. And because he took him to the farther one, the cop totally lost all jurisdiction to hold him. The second he decided to go to the guy farther away, all jurisdiction was lost. Void ab initio from the beginning. They become a trespasser ab initio from the beginning, and all of their acts are defeated. That is how the law reads. So that this whole idea of, oh, we're going to throw you in jail for 2 days or 3 days until a judge gets around to it. No. You have to take me to the closest and most accessible magistrate, even if it's 5 miles away, like I said, at 4 o'clock in the morning, and you know where the judge lives. Does not matter. You have to take him directly there. And I've had some of these old fellas tell me stories about that. Yes, that's exactly how it used to happen. Yeah, if a cop caught you out and about and you're really late at night, whatever, yeah, they'd drive you to the judge's house and he'd wake you up and you'd be all grumpy and you'd have to explain yourself. That was how it happened. And that's because that's the law. That's how it has to happen. So, and here's the thing. There's supposed to be magistrates everywhere. A mayors of towns are magistrates. I do believe, but don't hold me to this one, I do believe that city council members are also magistrates. I think members of wards may even be in some major cities magistrates. Anyway, they're all over the place. The point is that you don't have to go too far to throw a rock and hit a magistrate. So there's no excuse for the land pirates to take you any other place than where you should be going. So that's all right. So that's it about arraignment. Okay. So so if you have a contract with a corporate state, or you're already under the bus with the presumption that you were under the contract at the time that you were using the license, or that you gave the cop on the side of the road. So if you hand them the license, you're saying, yeah, I'm the presumption is that I was engaged in commerce on the side of the road. What you should do, and what Randy Kelton and Eddie Craig do down in Texas, what they do is that they get a state ID, and Blue Star and I and a few other people are working on the capacity of getting state IDs that do not have the social security number attached to them. And what the guys down in Texas do is they give the cop an ID, and then the cop will say, well, where's your license? And they'll say, I'm not using it at the moment. Which gets rid of the presumption that you're engaged in commerce. So anyway, it's just fun things you can play with them. So, okay, so some of the contracts that you have with the corporate state: fishing licenses, driver's licenses, registration of your car to the corporate state, the registration of your land to the corporate state, property taxes, and the like. Other things that you need to file before arraignment are a plea and abatement. So this is where you demand from the other side a clear answer as to who or what they are bringing suit against or charging with the statutes. Now, we just did a plea and abatement, and I'll show you the plea and abatement redacted here. We just did one recently with Blue Star as far as a debt thing, and they just completely ignored it. They acted like it was never filed, and they acted as if they had the slightest bloody idea what it was. Well, clearly they don't want to acknowledge it. I mean, I understand that, but the point is that a plea and abatement is a preliminary plea which does not go to the merits of the case. So when you file a plea and abatement, you are not granting the inferior court jurisdiction. Okay, you're not making a general appearance, because you're not making an appearance at all, because what you're demanding, what you're questioning is who or what are you suing? Fiction of law, state of Iowa, right? Who or what is the state of Iowa suing? Is it me, John Henry of the House of Doe, one of the people of wherever? Or is it John H. Doe or John Henry Doe, which is the name of estates or trusts? So which is it? So in this plea and abatement, what we do is and you guys can all use this perfectly fine. If you have any questions about how to use it, you can go ahead and contact me at whatever you want to. But this is kind of a rough draft of it, and we've slightly changed it from this, but this works perfectly fine. This was kind of more of a lengthy one that I took from someone else, but we did alter it to properly complete. The headings are a little bit off. Like, I would change the chapter thing, but if you just stripped it down for the information that was in here, it'd be perfectly fine. So what you're doing is you're saying, okay, your boilerplate starting point. So comes now John Henry House of Doe, a man, having been found to be living, having come to a full age, one of the people of Iowa, an American citizen, legitimate son of married parents, fully emancipated, donor, so lawfully appointed absolute general, instituted rightful executor, and so lawful general force testamentary, unconditional, heires heir sus. That's just 3 different ways to spell the word heir. Of both the John H. Doe, John Henry Doe, and aka all other derivative names, ipsodans, and spellings thereof estate, and any and all trusts that are derived from said estate, regardless of what said trusts are named, ever been named, so on and so forth, hereinafter demanded. Upon this plea and abatement, at law, in this court of record, hereinafter superior court. So again, what are you doing? You're filing this and opening up your superior court with it, saying, hey, what's going on here? Right? Upon this plea and abatement at law, okay, so to wit. So then your thing starts. Notice status, notice principal. To all these presents may come. Attached here 2 is the summons page, the complaint, the copy of your status docs, or at least your KW, and a copy of whatever other status docs you want to give them, and a copy of the recorded declaration of identification and recognition, or this was what that gentleman had called the document that he filed, which is why this is the same. This would basically be the declaration of nationality now. So again, you don't want to file this thing unless you know what you're doing. But so anyway, demanded places Iowa District Court for Louisiana County, hereinafter inferior court, on mandatory judicial notice of the fact that he is without counsel, is not schooled in the law and legal procedures, and is not licensed to practice law. Therefore, the filings must be read and construed liberally. That's just an aspect to make sure that they get off your back to saying, well, it's not, we don't know what this is, and it's not filed like an attorney would file it. Well, who cares? Further, demandant believes that this court has a responsibility and legal duty to protect any and all demandant's state constitutional rights. See United States versus Lee, so on and so forth. That's only, of course, if you've done your doc set. Demandant gives notice to all officers of the inferior court and defendants that all proceedings regarding this case number shall be abated and dismissed immediately because of all that is stated herein, or show cause why the demandant should not take lawful recourse against defendants in a suit at law, and or in binding arbitration proceedings as is stated and been served upon defendants in copy of public record number, yada, yada, yada. And that's, of course, your KW document. So, introduction, the defendant makes his choice of law to be the common law of Iowa and that of his own house. This is a plea and abatement issued pursuant to common law rules applicable to such cases against whatever bank or whoever the hell is coming against you. Defendants working in concert are imposing provisions of contracts counter to public morals in the nature of premature. Part 1 of this matter shall be known as plea and abatement and contains the following documents: plea and abatement and verification. And then you get into the plea. So these are the things that I sent back to you: the traffic ticket and complaint affidavit, or whatever they were. These papers were received and now returned for a refusal to contract and not accepted. These items are refused for cause without dishonor and without recourse to me, and were so returned herewith because they are irregular and unauthorized based upon the following to wit. And then you state why they're BS. And this gets into the aspect of being served with documents that are in the estate name, right? And so you're saying, hi, how you doing? And your papers do not have on their face of their documents proper name in upper and lowercase letters, nor do the additions to the complements upon their items herewith return applied to demand it. Your papers are alleged violations of law, foreign to demand it, with no oath, promise, or law attaches. Your papers have no foundation in law, and for that reason, they do not contain a name recognized by the defendant or the general laws of Iowa, and so on and so forth. I'm not going to read this whole thing, but it's all the reasons why basically their stuff is bullshit. The inferior court lacks subject matter jurisdiction over defendant's suit, therefore the suit should be abated. So I won't continue to read this because it has changed quite a bit, but you see where things start and how we flow through it. That's kind of what I wanted to show everybody. You know, we keep making things better. So, okay, so back to what you're doing in here. So you rescind the signature on any ticket you were forced to sign on the side of the road within 72 hours of getting it. That's important because you want to send back the ticket and say refuse for cause without dishonor and that you're not entering into contract. You have 72 hours to remove yourself from any contract, period. That's the law merchant for you. That's an aspect of the law merchant they can't get around. You always have 72 hours to rescind a contract, and any car dealership will tell you this. They'd be like, no, you have to come back within 3 days. We have to basically cancel the contract. So, as I said, many states have made this a non-issue because they don't even bother to ask you to sign anything and use the signature they gave you when your driver's license is proof that you've agreed to the jurisdiction. This is the aspect of taking power of attorney over you and using power of attorney through digital signatures. So anyway, it's better to send it back, particularly if they do force you to sign it. But even if you don't, I'd make a copy of the ticket and I'd actually have it served on whatever cop shop or sheriff's office gave it to you. And then you turn around and you also put a copy of that into the court record to say, nope, I don't have any contract. So you mail back to the agency that gave you the ticket, the rescission of signature, and make sure you file a copy in the court. That's what I just said. All right, serve the KW and the rescission of power of attorney on everybody up there. This lets them know what you're doing in regards to your state, and you'll put them under binding contract if they continue to administer your state. After you file all this and the corporate state fails to back off, these are the next things that you need to file. So, and take notice that there's no discovery at law here, okay? All the following tools in equity and Roman civil law tools are of the inferior court. So, Brady motion. The Brady request. So the redacted Brady request. Let's take a look at that real quick. So in the redacted Brady request, what a Brady request is you're asking for exculpatory evidence from the state. So that's any evidence that would prove your innocence. Okay. So request for discovery in Brady, yada, yada, yada. And now this is something that you would file into the inferior court. So this does go into their inferior court, but it still scares the crap out of them. So comes now Henry, so on and so forth, House of Doe, who is at all times a responsible man, being found to be living, come of full age, one of the people of Iowa, an American citizen, a free man, a freeholder, a free state of being, the legitimate son of married parents, and fully emancipated, hereinafter demanded. We hereby request counsel of the alleged plaintiff, state of Iowa, hereinafter alleged plaintiff, to provide the following discovery. So to continue, all the defendant's interactions with all government employees in this inferior court are under threat, duress, and coercion, only to avoid further aggression against defendant, and are not a waiver nor agreement to the jurisdiction of this inferior court. This is also a Brady request. Defendant requests the following from the alleged plaintiff's counsel as per all applicable Iowa rules of court. The names of every witness with personal knowledge the prosecution relies on to prove: A. Alleged defendant's presence within within the quote unquote capital S state of Iowa, right? So if I'm not in this state, which we'll get into in a minute, but if you're not in this state, sorry, I couldn't have possibly violated your law if I'm not in this state. Demandants present within this state. Alleged defendant's presence within the city of somewhere. Alleged defendant is subject to the laws of the state of Iowa. Demandant's presence within the city of somewhere, and demandant is subject to the laws of the state of Iowa. The Constitution and laws the plaintiff state apply to alleged defendant just because the alleged defendant is physically in Iowa, not in the state of Iowa. So that's big. There's a big difference there. A valid cause of action, injury and or damage, corpus delicti, has been presented to the court. And then 2, the name of any witnesses who are experts in the interpretation and application of Iowa law, including Iowa traffic laws, the prosecution relies on. Any and all evidence known to the complaining agent proving the alleged defendant and demandant was present within the plaintiff state of Iowa. Any evidence that we're in the city, again, any evidence that they're in the other city, right, demandant physically in Iowa. Any evidence, not allegations or opinions, a valid cause of action, legal injury, and damages has been presented to the court, which of course there are none, unless you actually did run into somebody, and that's a different story. The names of any other witnesses of personal first-hand knowledge the prosecution relies on to support any element of the alleged crime or cause of action against alleged defendant and or demandant, and which elements the witness is specifically relied on to create any complaint against said. So all the stuff that you allegedly are creating the complaint on. Oh, so you're telling me I was engaged in commerce on the day in question? Well, it says right here that I was driving. You did file this complaint, did you not, your officer? Yeah, you filed okay, officer, you filed this complaint. Okay, did you write this down? Well, yes, I did. Okay, define the word driving. Oh, you can't do that? Oh, objection, Your Honor. The witness is incompetent. Move to strike his whole entire testimony in the complaint. Bam, done deal. I mean, you can get rid of it that fast if you want to. I heard of a really wicked cross-examination one time against a cop. Okay, so it was the defendant's turn. So he asked the cop, he said, "Are you under subpoena to be here today?" Cop said yes. And then he asked some other question that was absolutely irrelevant. Something, or was it a clear day on the day that you pulled me over or something? Cop said yes. And then he said, "Are you being paid here to be here today?" And the cop said yes. And he said, "Your Honor, I moved to strike all the witnesses' testimony because being under subpoena is entirely different than being paid to be there. So it's either or." So he just simply caught him in a lie and then moved to strike his whole testimony because he lied on the stand and got it dismissed that way. So I thought that was brilliant. Okay, so anyway, to get back to this, the police officer's reports and notes regarding the stop and the arrest, including any video, audio recordings of the stop and any dash cam video. This includes, but is not limited to, true copies of the original complaint written by the police officer submitted to the court front and back, and all recordings of dispatched radio traffic between the officers and dispatched involved. That will piss them off because a lot of the times they'll say stuff back and forth with dispatch that proves that they'll say things they can't get out of in court. 9, evidence you have to prove the witness relied on professional first-hand knowledge of matters they are to testify to. Names of witness relied upon in the prosecution. Any material, including but not limited to audio, video recording, reports that may be used to impeach prosecution's witnesses. This means all of the cops' reports. Like if he's ever had bad reports against him, they have to produce his bad reports, right? So this also includes information and personal files from police investigators, any information that calls into question the witness's credibility, e.g. performance evaluations, disciplinary write-ups, and internal affairs investigations that concern a law enforcement employee's truthfulness, bias, or moral turpitude. This really scares the crap out of them because pretty much every cop has something against them. So anyway, submitted this day, so on and so forth, certificate, mail it, file it, make a copy of it, give it to the state, let them choke on it. So that's your basic Brady request. This is one of the tools you can use in equity to slam them. Okay, so to continue here, what else do you need to do if your estate is named as a defendant? You can do requests for admissions, you can do interrogatories, you can do depositions, and you can do judicial notices, and you can challenge the venue. And in challenging venue, and I know I kind of skipped over these kind of quick, but we're getting kind of late on time here. But requests for, well, all right, I'm probably much done at the end of this. Okay, I can go through these fine. Request for admissions. In a civil action, a request for admission is a discovery device that allows one It allows one party to request that another party admit or deny the truth of a statement under oath. If admitted, a statement is considered to be true for all purposes of the current trial. Parties may also use this discovery device to request that other parties verify that documents are genuine. So, foreclosure case. Great. Do a request for admissions. Admit or deny that the document that you've provided to the court that you call Exhibit A is the original wedding signature of the contract, right? The mortgage contract. And of course, the answer is going to be no. Things like that. You can get really sneaky with requests for admissions. Admit or deny the fact that you, as an officer, are an employee of the state who happens to be the plaintiff. Admit or deny that I was not carrying any cargo on the day in question. Admit or deny that I had no passenger on the day in question. Admit or deny that the definition of driving means to be employed under such and such whatever rule, however you want to run them over like that. So you can do all kinds of nasty shit with requests for admissions. You can also do all kinds of nasty things with interrogatories too. In a civil action, interrogatory is a list of questions one party sends to another as part of the discovery process. The recipient must answer the questions under oath and according to the case schedule. Because attorneys may help their clients answer interrogatories, interrogatory response tend to be more finely crafted than answers to deposition questions. The number of questions included in an interrogatory is usually limited by court rule. For example, Federal Rules of Procedure is just 25 questions per interrogatory. So again, these are all equity. This is all stuff in the inferior court. So I'm just giving you weapons. I'm giving you as many weapons as I can, but just remember that these weapons are in an inferior court, okay? And then depositions, that's when you have the other side, when you actually depose the other side. And you can do written depositions too to say, this is what I'm answering, how I'm answering it, and what I'm answering, so on and so forth. And then judicial notices. After you get all the rest of this stuff locked down, that they admit this, they admit that, and that you've got the depositions, then you do judicial notices on them to the court to say the court must take judicial notice of such and such that the officer has agreed that there was no evidence that I was engaged in commerce on the day in question. Things like that. And that makes the case really easy because they can't prove anything, at least with the traffic case. So that's your little attacks there. Now let's get into venue. Make sure that you're in the right venue, meaning that you're not in this state. So let's pull up that. These two are pretty much the same. So just one is based in Texas. One was altered for Texas law, and the other one's altered for Iowa. And these were both altered and created by students. State of Texas, State of the United States versus geographical Texas Union State. The United States Supreme Court has held that the term of the United States means belonging to the United States. The states of the Union are not territories of the United States, right? Because they're states of the Union, right? They're their own republics. And do not belong to the United States. The states of the Union have a sovereignty that predates the creation of the federal government. Yes, of course they do. It's called the Articles of Confederation. However, the territories have no sovereignty as they are the property of the United States government. Thus, the term states of the United States, as expressed in federal codes, includes only the territories as inculcate states which belong to the United States. So if you're saying a state of the United States, so the capital S state of Iowa, if you're in the capital S state of Iowa, you are in a capital S state of the United States. If, however, you are in a lowercase s state of the Union, notice the capitalization here, the lowercase s states of the Union, the term capital S state of the United States. So you are in a lowercase s state. You're domiciled in lowercase s state. You technically yourself are a lowercase s state. If you really want to get down to the very meat and bones of what sovereignty is, you are a lowercase s state, right? So whenever you see this, just make sure that you're paying attention to uppercase and lowercase s state here, okay? And it's the same throughout all the law. They're very consistent. They do not screw this up. So Introduction, Law and Facts, aspects of the Articles of Confederation gave birth to the formation of the Confederation of the 13 perpetual sovereign independent states. Note Article 1 above, the style of the United States of America, meaning belonging to America. Cannot be said the Articles of Confederation were also America's first constitution, and I would say yes. Article 1. This is directly out of the Articles of Confederation, by the way. This is how it starts. Article 1. The style of this confederacy shall be, capital T, the United States of America, close quote. That's the style of the Confederacy. So Article 2. Each state, lowercase s state, notice that, retains its sovereignty, freedom, and independence, and every power, jurisdiction, and right which is not by this confederation expressly delegated to the United States in Congress assembled. Congress being a formal assembly of representatives as of various nations. That's Webster's dictionary. So, fact in Volume 1, page 1, the United States Code recognizes the 4 organic laws of the United States of America as being the unanimous declaration of the 13 United States of America, the Articles of Confederation, November 15th, 1777, the Northwest Ordinance, July 13th, 1787, and the Constitution of the United States of America, September 17th, 1887. Notice this, just as a side history note here. Notice this. Notice that the Northwest Ordinance was being laid down and was finited, and then at the same time they were organizing the Constitution. Listen, the people that really knew what were going on, they wanted the Northwest Ordinance laid down to make sure that the goofballs who were going to try to take over things from having a centralized power were never able to alter the common law of all of the Northwest Territory. So, just as his historical note, that's an important thing to remember here. So, take note. One of the 4 organic laws, the Constitution, Article 1, Section 8, Clause 17, to exercise exclusive legislation in all cases whatsoever over such district not exceeding 10 miles square as may, by secession of particular states and the acceptance of Congress, become the seat of the government of the United States, and to exercise a like authority over all places purchased by the consent of the legislature of the state in which the same shall be, for the erection of forts, magazines, arsenals, dockyards, and other needful buildings, and to exercise exclusive legislation in all cases whatsoever. This is territorial jurisdiction to which the Constitution limits the federal government, as also declared in the Articles of Confederation, right? So, what do the feds have power over? Only what they own, and that little 10 square miles, that's it. So what have they done? They've created a situation where they consider everybody to be a citizen of that 10 square miles. That's what they did. So, or there's another aspect to it, that they consider all of the states, now this is the lowercase s states, they consider all the states to be conquered territories now of the federal government after the Civil War. Which, again, if you watch Richard McDonald's lecture on state citizenship on YouTube, which I'm sure it's still up, he states in there, he tells you that he wrote the Congressional Research Committee and asked them, are the states conquered territories after the Civil War? They wrote back and they said yes. So until we get rid of this stupid emergency, which Lincoln created way back in the day when they went batshit crazy, and the Rothschilds came in and funded both sides of the war and blah, 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 blah. I don't want to get into everything because it's impossible. But point is that we got hoodwinked. They created a federal corporation. They moved everything into the federal corporation, and then they lied to everybody about what they were doing. Short story. Very, very abbreviated short story. But that's basically it. So the aspects of in this state, okay, right? So the Supreme Court has held the United States of America. In the United States of America, there are 2 separated and distinct jurisdictions, such being the jurisdiction of the Union states, number 1, within their own state, lowercase s state boundaries, and the other being federal jurisdiction, United States, number 2, which is limited to the District of Columbia, the U.S. territories, and federal enclaves within the lowercase s states. There you go. There it is, in your face. That's what it is. Now, the United States Supreme Court has also held the idea prevails where some indeed have found expression in arguments to the bar that we have in this country substantially or practically 2 national governments, one to be maintained in the Constitution with all its restrictions, the other to be maintained by Congress outside the independency of that instrument by exercising such powers as other nations of earth are accustomed to exercise. It is one thing to give such latitudinal construction to the Constitution as will bring the exercise of power to Congress upon a particular occasion, or upon a particular subject within its provisions. It is quite a different thing to say that Congress may, if it so elects, proceed outside the Constitution. The glory of our American system of government is that it was created by a written Constitution which protects the people against the exercise of arbitrary, unlimited power, and the limits of which instrument may not be passed by the government it created, or by a branch of it, or even by the people who ordained it, except by amendment or change of its provisions. And this is Downs versus Bidwell, which is a really interesting case, which everybody should just read anyway, because there's a lot more stuff in there. The most important, well, I shouldn't say the most important, but I think one of the most interesting parts of Downs versus Bidwell is read the dissenting opinion, the whole entire dissenting opinion of Justice Harlan, not just this part of it, but the whole thing. And, he goes off and it's like, this is ridiculous. You're just saying that, okay, you guys just have all the power in the world now. You just do whatever you want to. So anyway, okay. Since the government derives its just powers from the consent of the governed, i.e. us Texans, one of the first questions to ask the government might be for the definition of these words. Natural person, resident, and the phrase in this state, or capital S state. So that's the person thing. I want to get to into the state part. This is an interesting one. Texas Code definitions. State means a state of the United States, the District of Columbia, the Commonwealth of Puerto Rico, the United States Virgin Islands, or a territory or insular possession subject to the jurisdiction of the United States. Right? There you go. So, can you ever be in this capital S state? Not unless you're in the territories. And what does every single statute say on the state side? It says, if the defendant is in this state, okay, prove venue. Prove I was in this state. Can't do it. If they don't have venue, they have nothing, by the way. You don't even have to worry about anything else. You don't have to worry about subject matter jurisdiction. You don't have to worry about in personam jurisdiction. Nothing. If they don't have venue, they don't have shit. They have nothing. No thing. Zero. It's like trying to charge somebody for a crime that happened in France when you've never been in France. Right? Same idea. So, anyway. So this was the point that I was trying to get at. So the aspect of in this state, you can see these definitions. They're blatantly clear. All capital letters, state. State means the state of the United States. Territory, same damn thing, right? Again, general definition. State means no, same thing, right? So, yeah, state means the capital S state of Texas. Again, a fiction. Capital S means fiction. Lowercase s means consists of. Okay. A state of the United States and the District of Columbia are one state, right? So that's again talking about what they stated above. Okay, here we go. This is the one. In this state means within the exterior limits of Texas, capital ST Texas, and includes all territory within these limits ceded to or owned by what? Owned by the United States. Okay, we clear? Yeah. So this is venue for you. And then this gets into other things. What's a governmental entity? What's a municipality? So on and so forth. And then I can't remember who created this interesting little flowchart, but anyway, the different jurisdictions and what is or what is not in this state, revenue, that's kind of fun stuff. So anyway, I gave this to everybody to know that there's a clear difference between the venues, and it doesn't deviate. It's correct in every single state, and they tell you right up front. You're just not paying attention because people don't know that there's a difference between the federal conclave and overlay of capital S states and lowercase s states. So. And then the treatise in this state in Iowa is essentially the same thing. It's just set for Iowa. So you guys can look at you can pull up your Iowa codes. You can whatever state you're in, go pull up the codes, read them. They're all in your face as to what the jurisdiction is. It's what the venue is. Because like I said, if they don't have venue, they don't have anything. So this is Iowa's, right? So I give this to everybody, and as a homework assignment for every single man and woman who ever comes across this lecture series, please feel free to join the Vocational Science of Freedom Gilded server and write your own treatise for your own state and add it to our collection so we can eventually have one for every single state. I think that'd be great. If you could lay this down, a treatise like this for every single state, honestly, they just wouldn't have anywhere to go. They would just be stuck every single time. But that's one of the big things that a gentleman by the name of Al Barcroft used to do, who I think is passed on now. But Al Barcroft, what he used to do was he used to get people up on the stand. He'd ask them 2 questions. 2, that's it. He'd say, do you have a social security number? They'd say, no. Are you a citizen of the United States? No. Bam, case dismissed. That's it. Of course, he was an attorney who went rogue, but I mean, if you have somebody that can ask you questions, appoint your special master. Give him the questions. Yeah, Your Honor, I'm going to ask. Okay, we're going to put you up on the stand. We're going to ask these questions. Okay, great. It doesn't have to be an attorney. It could be your special master can answer those 2 questions. Are you a citizen of the United States? No. Have you ever had a social security number? No. And would you be lying on either one of them? No. Because the estate is what has the social security number, not you, not the living man. You're not issued a social security number. Your estate is issued a social security number. And to prove that to you, all you have to do is look at the IRS tax forms, or the different classes of IRS tax forms. All W-9 IRS tax forms are all Class 5. Class 5 is gift and estate tax. It's not income tax. Okay? Anybody ever bother to look that up? Probably not. But it's blatantly in your face that you're paying a gift and estate tax. Why? Because you haven't claimed it. Okay, so anyway. So I'm going to open up the easy guide. This is just an example from Jurisdictionary. Pain to everybody that wrote Jurisdictionary, and please buy their course. I'm just doing this as a promotional guide. I'm not trying to, to give this one document out to do any copyright problems. So I just want to show you guys that it's a really good, Jurisdictionary is a really good course to learn how the flow of court works. Now, granted, Jurisdictionary, forewarning, this is all equity. This is all Roman civil law. His whole course is how to win in Roman civil law. Now, I'm saying you don't want to go down that road. You simply want to stay in a court of record and do everything that we're doing, and you don't have to worry about this shit. But if you want to learn how the ebbs and flows of court work, this is the best course to buy. I think it's still only like $250 or maybe $275. It's really well put together. It has handouts and documents that are very easy to follow and use, like this. And it'll teach you how court works. It's $250. Okay, thanks. And it's worth it. Even though, just always remember that this is based in equity. Okay, and Bill Thornton will tell you that too on his website. Say, yep, it's a good course, but it's equity based. So I'm not going to go through all this. It's 18 pages, but just the basic of how these things flow. So you have your complaint. In equity, you file a complaint. At law, you file an action, or you file an original writ, like a high prerogative writ, like habeas corpus, mandamus, quo warranto, whatever. And then you have, at common law, you'd have your preliminary motions, like pleas and abatement, plea to the writ, to fix these various different problems and stuff, and whatever, blah, 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 blah. In equity, you just go straight into motions, and everybody just goes back and forth, and they consider that the jurisdiction is assumed, basically, in equity, unless you do the preliminary motions, like I said, over here before you even come in and start these. Because if you file any motion in equity that goes to the merits of the case, you've agreed to the jurisdiction. So don't do that. Never file a motion to the merits. You only ever file motions to dismiss based on lack of subject matter jurisdiction, lack of impersonum jurisdiction, lack of venue, which is the big one, which we just went over, and pleas and abatement. That's it. That's how you file in any equity thing, which is directly challenging the jurisdiction of the court. But again, to stay out of equity, just file a counterclaim at law and challenge the jurisdiction that way. Or file a plea and abatement at law. Or serve everybody the doc set and then run them over in binding arbitration. I don't care, but don't go wandering into equity courts for no reason. That's what I'm getting at. So you have all the motions back and forth, and then the defendant has to answer the complaint, and then you do discovery. Okay, who's got what, where, blah, 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 blah. And then you put all this stuff formally, and then you present it to the jury at trial, or the judge, or the chancellor, the black girl priest of hell, whatever. So he goes through about how to preparation. Again, first step to winning is preparation. This I'll stand by this without question. It doesn't matter what you're doing. That's just a true statement, regardless. So make sure that they prove their burden of proof, and that means for everything. Again, impersonum jurisdiction. Do they have jurisdiction over the person, over the estate? Yes or no? Subject matter jurisdiction. Do they have jurisdiction over the subject matter? Meaning, is it a thing of traffic? Or can they prove you were in commerce? Do they have venue? Right? Can they prove you were in this state? Burden of proof. Prove it. Can't prove it? We'll dismiss. Out of here. Right to sue, cause of action. So know what your causes of action are, and this would be true for equity and at law. So know what your causes of action are. And there's a list of common law causes of action that are in the law library. The complaint, again, this is a complaint in equity. It would be an action at law, or this would be also you consider this would be a bill in equity compared to a declaration at law. Those are also the two opposite things of the two terms. So you do the motions, motion to strike, motion to dismiss, motion to more defense statement. So you see how he's saying, yeah, go ahead and do all these motions. Lacks jurisdiction, lacks subject over the defendant. The summons was defective. Complaint fails to state the cause of action. The case is filed in the wrong venue. Okay, bam, right there. So anyway, so like I said, I'm not going to go through all this, but jurisdictionary is a good layout of it'll teach you an awful lot about how court works, particularly about how the system of Roman civil law works. Now, like I said, of course, there are differences between Roman civil law and common law, but if you went at this first and then you realize that, and then learn your common law, that's fine. You could do it that way, back and forth, right? It doesn't really. But what I try to do is teach everybody how to do things at law first, and so that they know the differences between equity courts and at law courts, so that they do not confuse them, and so that you do not get into contradictory arguments where you're in your court, like say for example you're in your court of record and you say something that would be contradictory to your court of record, like you say you bring up a statute or something, right? Well, statutes are equity. They don't, that would be frivolous. Just like when they would argue statutes in your court of record, you'd say, objection, Your Honor, frivolous. What's he doing? He's yelling touchdown on a basketball court. Move to strike. That kind of thing. So anyway, I highly suggest getting jurisdictionary just to go over these basic other things, like how do we do summary judgment, maxims of common law, causes of action. All these things are interesting and they're important to learn anyway. But just know that it's based in equity. So with that said, that's all we have for today. And I hope everybody had a good time. And I hope that you take the time, as always, please, please, please take all the time to read and go over all of the documents that are given. The all-day law courses that I set up for this to give all these handouts are all necessary basically to get you through an entire month. And I know that's a lot, but to get you through if you literally sat down for an entire month and studied just every single thing that I gave you in one class to the next month, you'd have every bit of information you could possibly handle for learning, okay, till the next month. That's why I do it like this. So the class outline is designed for someone who wants to learn as fast as they possibly can. And I'm doing this in the way that I learned it, so that you don't make the same mistakes, so that you can go through things very quickly and that you can understand these basic concepts, and so that no one can tell you different. That you can pull up that treatise and you can be like, nope, this is not what is correct. This is what this treatise says, and here it is in your face. So they can't get out of it. So please take the time to read all the documentation and to feel free to ask me any questions just anytime. Anybody on Gilded. That's why we have the server up, so that we can have this discussion. And if you find anything wonderful, interesting things, make sure that you feel free to post them in the Gilded channels as you see fit. Feel free to share, because that's why the server's here. So thank you everyone for coming. Thank you everyone who participated, and thank you everyone who paid for the class. And I appreciate the help and support as always. And of course, if you got any other questions, you can DM me later. So have a great night.